Philosophical or legal pacifism represents a distinctive strand of pacifist thought that does not begin with religious command, moral absolutes, or tactical resistance. Instead, it begins with reason, law, and institutional design. Violence is not rejected primarily because it is sinful or ineffective in the short term, but because war is a structural failure of political organization. If human societies were properly ordered, war would become unnecessary. This tradition reaches its most influential articulation in the political philosophy of Immanuel Kant, particularly in his vision of a lawful international order capable of restraining violence through reasoned institutions. Kant's starting point: war as a rational problem. Kant was not naive about human nature. He did not believe that people or states would spontaneously choose peace out of goodwill. On the contrary, Kant assumed that self-interest, competition, and conflict are enduring features of political life. His question, therefore, was not how to make people morally perfect, but how to construct systems that prevent their worst impulses from producing catastrophe. From this perspective, war is not an unavoidable expression of human nature. It is the predictable result of anarchic political conditions, especially in international relations. When states exist in a condition analogous to individuals in a state of nature, without binding law or enforcement, violence becomes rational even when it is tragic. Philosophical pacifism, in Kant's framework, does not rely on moral exhortation. It relies on legal constraint. Perpetual peace, war as a solvable institutional problem. Kant's most important contribution to pacifist thought appears in his political essay, Perpetual Peace. There, he argues that peace should not be understood as a temporary ceasefire between wars, but as a permanent condition secured by law. Kant advances several interlocking claims. Republican constitutions reduce war states governed by representative institutions are less likely to wage war because citizens who bear the costs of conflict must consent to it. War becomes politically expensive rather than a ruler's personal ambition. A federation of free states can restrain violence. Kant does not imagine a single world government, but a voluntary league of states bound by legal norms. This federation creates predictability and mutual restraint, replacing force with adjudication. International law must replace power politics. As long as states rely solely on military strength to secure their interests, war remains rational. Law transforms interest by redefining what counts as legitimate action. In this model, peace is not achieved by moral transformation alone, but by structural incentives that make war irrational. Legal pacifism and the role of institutions. Philosophical pacifism places extraordinary confidence in institutions. Courts, treaties, constitutions, and international organizations are not secondary mechanisms. They are the primary tools for eliminating war. From this perspective, war persists because there is no enforceable global legal order. Violence declines when law becomes predictable and binding. Peace is sustained not by virtue alone, but by procedural justice. This logic directly influenced later developments in international politics, including the League of Nations and, more enduringly, the United Nations. While Kant did not design these institutions, his philosophical framework provided their normative justification: peace through law rather than domination. Distinguishing philosophical pacifism from moral pacifism, philosophical or legal pacifism differs sharply from theological or absolute pacifism. Kant does not argue that violence is intrinsically immoral in every instance. States may still defend themselves in unjust conditions. What Kant insists is that permanent peace requires replacing force with law, not merely restraining violence case by case. In this sense, legal pacifism is future-oriented. It tolerates coercion temporarily, while aiming to eliminate the conditions that make coercion necessary. The goal is not moral purity, but systemic stability. This creates a tension within Kant's pacifism. War is condemned as irrational and destructive, yet occasionally acknowledged as unavoidable until proper institutions exist. Peace is therefore a project, not an immediate command. Peace as a moral duty of reason. For Kant, peace is not optional. It is a requirement of practical reason. A world in which war is normal undermines human dignity, legal accountability, and moral responsibility. Violence interrupts the conditions under which ethical life and rational judgment can flourish. Thus, philosophical pacifism frames peace as a duty of rational beings, not simply an aspiration of the virtuous. Institutions are the means by which reason disciplines power. This marks a crucial shift in pacifist thought. Peace no longer depends on universal moral agreement or religious conversion. It depends on rules that even imperfect moral agents must obey. Conclusion: Kant's enduring pacifist legacy. Immanuel Kant stands as the foundational figure of philosophical and legal pacifism because he redefined the problem of war. War is not inevitable, it is engineered by bad political design. Change the design, and war becomes obsolete. His legacy endures in every serious attempt to govern international relations through law rather than force. While the project of perpetual peace remains unfinished, Kant's insight continues to shape global political imagination, that lasting peace will not emerge from goodwill alone, but from institutions strong enough to restrain violence and rational enough to command legitimacy. Philosophical pacifism, therefore, does not ask humanity to become angels. It asks humanity to become lawful.